The American Illusion. Background and framework. The Roman civil law republican government founded by the original Constitution, 1787, is claimed no longer operational. Instead, what is called the Government of the United States is a bankrupt private corporation, owned, underwritten, and functioning in commerce as a front for the international bankers and the powers that be with which said bankers are allied. The entire institution, i.e., US Inc., is private, not free, enterprise administering the ongoing business and political ends of the actual owners. In this current scenario, every action of US Inc. is a commercial transaction by and between fictitious entities, all transpiring for the purpose of furthering the economic and political objectives of the alleged creditors. This situation arose from the borrowing by USA from European central banks and owing the unpaid indebtedness to the Crown from the original joint venture agreement between the colonies, which are corporations of the Crown, and the Crown per se. It appears as though USA has been bankrupt from inception, i.e., from 1788, and the Constitution was drafted to reconstitute the unpaid debt and structure an organization for functioning in bankruptcy. The Civil War was staged and financed by the bankers and the Crown to conquer the nation by engaging in the timeless strategy of divide and conquer. Pitting North against South resulted in the dissolution of the de jure federal government of the organic Constitution. The states were drawn into the central government, as were, progressively, the people directly, with the whole conglomerate operating through the new federal government in the emergency war powers of 12 Stat. 319, 1861, under the law of necessity. Thus, the government functions under mere color, appearance only, of government, with the president as acting dictator on behalf of the bankers under the president's capacity as commander-in-chief of the military. I.e., when the 7 Southern states walked out of Congress on March 27, 1861, Congress, and, indeed, the entire de jure government of USA under the original Constitution, dissolved based on absence of a congressional quorum to adjourn and reconvene. The result is that the actual winner of the Civil War was neither the North nor the South, but the bankers who owned the new federal government that defeated both North and South and absorbed and subserved the states into itself. In accordance, inter alia, with the Limited Liability Act of 1851, the Emergency War Powers, 12 Stat. 319, the Civil Rights Act of 1866, and the constitutional provision allowing Congress authority to pass any law Congress wishes within the 10-mile square territory of Washington, D.C., Article 1, Section 8, Clause 17, the 14th Amendment was proclaimed ratified in 1868. Within that framework, on February 21, 1871, Congress passed the District of Columbia Organic Act, 41st Congress, Session 3, Chapter 62, page 419, 16 Stat. 419, an act to provide a government for the District of Columbia, which act was revised in 1874 and reorganized June 8, 1878, 20 Stat. 102, Chap. 180, 45th Congress, 2nd Session, an act providing a permanent form of government for the District of Columbia. This government is a private corporation now known and copyrighted by such names as the United States Government, United States, US, USA, etc., all referenced herein as US Inc. It is important to understand that US Inc. is not a country, but a corporation, and indeed a bankrupt corporation operating under color of government as the front and device for administering the conquest in law and commerce of the United States of America. The 14th Amendment and US Inc. are all private international law in the Admiralty Maritime Law Merchant of Roman Civil Law. The 14th Amendment states, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. This amendment allows US Inc. to have complete jurisdiction over citizens, i.e., corporate subsets of US Inc., which the de jure federal government did not and could not possess. The 14th Amendment also states, Section 4, the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, per 12 Stat. 319, shall not be questioned. The 14th Amendment established the framework for complete conquest and absorption of the country, rendering the people permanent debtors, indentured servants in involuntary servitude, peonage, and also enemies of the government as a result. In accordance with 12 State 319, any aspect of US Inc. may summarily confiscate property in rem without necessity for judicial process whenever any citizen asserts a challenge to the laws of the United States, i.e., US Inc. Remnants of the de jure government remained after the 14th Amendment, however, based on such things as the continuing circulation of gold and silver coin, the money of sovereigns, and the fact that senators were still elected to the Senate by electors of the states rather than by direct, popular vote. Senators became elected by direct vote of the people with the passage of the 17th Amendment. The Civil War had forced each sovereign state to pledge its assets as collateral and become surety and a cosigner for the defaulted federal government's debt to the bankers. This procedure was repeated in the 1933 bankruptcy, at which time gold and silver coin, substance, were outlawed as money for citizens of the United States, fictions. Inability to use gold and silver as money solidified the bankruptcy of US Inc. and foreclosed every such citizen from accessing real money for use in payment of debts, thereby denying access to sovereignty. US Inc. is completely devoid of rights, substance, standing in law, and sovereign character, as is every citizen of the United States. The creation and nature of the strawman. Because additional pledging of assets was required to enable the now bankrupt corporation to continue to operate when civilly dead, the governors of all the states met to discuss the emergency declared by Franklin D. Roosevelt, i.e., the bankruptcy, and how to reorganize US Inc. to continue functioning when bankrupt by means of insurance underwriting by the creditors. The governors of the states made a pledge to US Inc. to underwrite the bankruptcy through a grand scheme of limited liability insurance. The people, through their certificates of live birth, aka newborn identification, were registered in the office of the county recorder by registered agents of the government such as the registered doctor and registered nurse, and were thereby established as property of the state. Remember, register derives from regius, meaning king, whereby everything registered is there to record and keep track of the king's property. The newborn identification is identified with, and attaches to, the flesh and blood being by taking a drop of blood and the print, usually footprint, of the baby and applying them to the newborn identification. Once that certificate is registered, it is recorded as a certificate of title, as it were, to the real being. Since the point is to be able to enslave the child and render him a surety for the debt of the bankrupt US Inc., it makes no difference who or what the baby is. Everyone becomes classified as fungible goods, like interchangeable bales of cotton. The parents did not understand what was happening, so the process was thereby fraud based on deceit and non-disclosure. Obviously, with full disclosure of the terms and conditions involved in the alleged contract, no one would agree to go along with it. The agents of the government perpetrate a fraudulent transfer by registering the name, blood, and footprint of beings that is birthed by the living woman and not the corporate state, which can generate only more legal fictions, not real beings. This process amounts to theft of the real being by filing a piece of paper. The state did not create the name from which the all-caps strawman was derived, only colored the name into a form they could use. The name in upper and lower case letters pertains to the real being, while the all-caps strawman is a legal fiction used as credit against which to borrow at the expense of the life force of the living being to which the name and registered newborn identification allegedly relates. When the governors of the states, at the Conference of Governors of March 6, 1933, pledged as state-registered assets the newborn identifications of those born in the state to the federal bankruptcy, the People's Energy was established as the collateral for backing the whole operation, the entire national debt. Since the states, being fictitious, commercial entities with no capacity to recognize real beings, could not pledge private, living people or their property, a bridge was needed between the living people and the bankruptcy of the federal US Inc. To accomplish this result, the Department of Commerce in Washington, D.C., in order to function as a shield to operate out front publicly in place of the people, created the strawman. The scheme had to be so clever that the people would agree to operate as surety for the debts, charges, and obligations of the strawman without knowing what was happening to them, who did it, what they were agreeing to, or how the whole process worked. The birth certificate with the all-caps name created by the U.S. Department of Commerce is a certificate of equity interest, akin to a pink slip, pertaining to a vehicle, and possibly a bill of lading, a document of bailment, which ships the cargo, new and original birth certificate, into the special maritime jurisdiction of the creditors to operate as collateral to back the bankruptcy reorganization of US Inc. via the governor's pledge. The all-caps strawman is thereby birthed, like a vessel, into the private, international law special maritime jurisdiction of the bankers, al., as a citizen of the United States born, birthed, or naturalized in the United States and subject to the jurisdiction thereof. By this scheme the living people assumed the role of guarantor, accommodation party, and surety for the legal fiction that functions for the benefit and enrichment of the creditors. In this scenario it is the strawman, not the living being, that operates throughout the entirety of today's law and commerce. One need only look at the Social Security card, school records, passports, driver's licenses, credit cards, utility bills, etc., all of which are always in all capital letters, just as are gravestones of dead people all over the world and the parties to a dispute on the caption of a court brief, to see the ubiquitous use of the strawman in today's commercial and legal world. A surety is defined as the one who is responsible to pay. The real man is the surety and liable by contract to pay for the debts and obligations of the strawman, even though the real man is not, nor does he own, nor does he receive title to, anything purchased or accomplished by use of the strawman. The strawman is owned by US Inc. and the banks that purchase bonds issued by the Treasury against the strawman as credit. As stated, US Inc. is bankrupt, and has been since 1933. US Inc. has no gold or silver to pay any debts and is civilly dead. Having neither possession, nor right of possession, nor legal capacity to use gold and silver, i.e., lawful money, the only asset left to finance the continued operation of the bankrupt US Inc., i.e., the government, was the people, who were hypothecated as the credit collateral to finance the bankruptcy. US Inc. uses the substance and labor of the people to finance its entire operation, reorganization and insurance underwriting. The scenario is extremely sophisticated, resulting in the operation of a vast and pervasive administration of legalized peonage, slavery, permanent indentured servitude, and collectivism, communism, wherein the people have forfeited all standing in law and are dead to rights. The powers that be borrow against your life, rights, and labor to finance their administration of the system they use to exploit, plunder, and dominate you, all under the presumption that they are acting as your agents to fulfill your own requests. In this scheme, one is punished when one fails to pay or obey. The sequence of steps involved in creating the existing system, in accordance with the best research to date resulting from the efforts of many devoted people, is as follows in the United States. 1. A living, flesh and blood baby is born from its mother's womb. 2. The legal, commercial system, existing and functioning entirely in the abstract realm of words, contracts, legal persons, corporate entities, laws, symbols, ideas, commerce, private international law, etc., which constitutes the matrix, cannot see, recognize, or deal directly with the real world, including real people. The system itself is imaginary, while the real world is genuine and substantive. Consequently, the system deals only with documents and matters in the abstract realm that form, by presumption, ratified implied contract attached to the real world by operation of law and the tacit consent of the people. 3. Just after birth, the involved doctors and hospitals have the mother sign a birth certificate, i.e., a certificate of live birth, without telling the mother, and undoubtedly without themselves knowing the truth, that by so doing she and the doctor are criminally informing on her newborn baby as an enemy of the state in accordance with the war powers and turning the baby over to the bankers as chattel property and slave, pledging the baby's life energy and labor in perpetuity as the collateral for borrowing into existence all currency. Debt paper that passes as money today. 4. The original birth certificate, a certificate of live birth, constitutes, as it were, a certificate of title to the real being, and is in essence the equivalent of a manufacturer's statement or certificate of origin, i.e., MSO or MCO, which is created upon manufacturing an automobile and constitutes title to the vehicle. 5. Just as in the case of a car, anything being registered in the legal system is established on the record as property of the king. The key here is registered, a word deriving from regius, meaning king, whereby everything registered is recorded as the king's property. 6. The sequence of steps concerning the birth certificate appears to be as follows. A. After registration of the certificate of live birth in the office of the county recorder makes a certified, true copy or microfilm, retains it, and sends the original to the Department of Commerce in the state. B. As in the case of the county recorder, the State Department of Commerce makes a certified, true copy or microfilm, retains it, and sends the original to the Department of Commerce of the federal government in Washington, D.C. C. The Department of Commerce in Washington then makes a certified, true copy and, in addition, creates a new document, constituting a certificate of equity interest, which is labeled birth certificate. This birth certificate, however, has the child's name in all capital letters, unlike the original birth certificate filed in the county recorder on which the name was in upper and lower case letters. D. The Department of Commerce in Washington, D.C. then forwards the originals of both documents to the record repository in such locations as The Hague, for holding on behalf of the international banks, e.g., the World Bank, the Bank of International Settlement, IMF, AL. There the documents remain on deposit as the collateral asset for hypothecating into existence the credit that finances the underwriting of the world's bankrupt governments. 7. By this means, the people become the utility for the transmission of energy from reality into the fictitious, colorable realm of international commerce. The private, international law that governs the legal, commercial system today is the Uniform Commercial Code, which is established as the law of the land in the United States in Public Laws 88 to 243 and 88 to 244. The UCC is private, not public, law, and is copyrighted by Unidroit, an Italian corporation out of the Vatican. Now the people, via their all-caps names, are classified as human resources and goods under the Uniform Commercial Code, see section 2 to 105(1) and 9 to 105(1), in which animals, i.e. humans and their unborn offspring, become goods saleable in commerce. The Department of Treasury issues bonds on the birth certificates, which are sold through securities exchanges and purchased by extending credit on the bank's books by the Federal Reserve Bank, which uses the bonds as reserves for creating credit in the fractional reserve system. The people's labor becomes the collateral for issuing Federal Reserve notes or some other form of debt obligation, see 18 U.S.C. section 411. The bonds are held in trust for the purchaser, now the secured party, and holder in due course, at the Resolution Trust Company at 55 Water Street, in New York City, about 2 blocks down the street from the Federal Reserve. It is a high-rise office building with a sign that reads, "The Tower of Power." After the New Deal, the all-caps name, hereinafter, strawman, is what the system deals with, since it cannot interface directly with real beings. The real being, however, is presumed to have ratified the deal, agreed to the pledge, by the 3 means for signifying ratification of implied contracts. Thereafter, the system functions on the basis of possessing complete authority to do anything it wishes with the strawman, which is the system's own creation and property and does not belong to the living being to whom the strawman purportedly pertains. This scheme of legal, commercial peonage and slavery is outside the Constitution, which does not apply in any matters concerning the resulting process. The system functions in the realm of private contract, private international law, in international commerce, i.e., the private international law of the private, colorable law merchant, not within the direct purview of the Constitution, which merely sanctifies the operational right to contract. Thereafter, every time the real being signs his name on any legal, commercial document, he is creating more debt currency into existence, signing as the surety, or accommodation party, per the Uniform Commercial Code section 3 to 415. He is also placing title to whatever property is involved in the hands of the bond holder. In this scenario, the name, i.e., strawman, is credit and is a constructive trust created by operation of law, i.e., fiat, holding all the real assets, i.e., sweat equity, created by the labor of the real being. The right to the use has been separated from the title. The strawman holds the title and belongs to the bond holder, not the real being. The flesh and blood man or woman has only naked possession with a limited right to use the thing, such as one's body, possessions, or land. Such illusion of ownership and right is essential to maintain the sting on an ongoing basis, keep the people from completely rebelling if the status as slaves was self-evident, and fostering more enthusiasm to work and produce by thinking that they are doing so for their own benefit rather than for the enrichment and power of their owners, masters, rulers. When the strawman violates some rule or statute, such as is presumed whenever the strawman receives a traffic ticket, the flesh and blood being must appear at an arraignment and admit that he is the surety and accommodation party for the strawman, and thereby agree to provide the energy necessary for providing whatever fine or penalty is deemed due and payable. The real being has reconfirmed the contract of implied unification of the real being with the strawman by saying, here, when the strawman's name is called in the idem sonans, i.e., same sound, tribunal. This is why it is essential for the operation of the system that people voluntarily give their names to the court. The defendant in the action is the strawman, not the real being. The real being confirms that he is, or may legally be treated the same as, the defendant. Through this process one has entered through a door over which is inscribed, "Abandon hope all ye who enter here." It is now clear that the strawman is 1. A nom de guerre, meaning a name of war, whereby the strawman is regarded as being in a state of insurrection or rebellion, per Section 4 of the 14th Amendment, 12 Stat. 319, and the Trading with the Enemy Act, 2. At straminius homo, or strawman, the legal and commercial consequences, aspects of which are that it is a permanent debtor in legal incapacity, a dead estate, 3. An artificial entity owned by the secured party who bought into the bond placed on the market by the U.S. Treasury. It is important to remember that the strawman is not the property of the real being. The living man or woman is merely the surety, succor, providing the labor, life energy, and sweat equity for the fiction owned by US Inc. and the bond holder. The strawman is the front that enables the secured party to act in legal, commercial dealings without revealing his identity, and to deceive the real being, who signs in all matters as a surety and accommodation party, into thinking that the real being is doing something for himself rather than his owners, masters. Everything the real being signs on behalf of the strawman places title to whatever property is involved into the hands of the United States and the bond owner, i.e., the secured party over the strawman. Do the American people have a claim on their all-caps strawman? The short answer is, yes, but only after the American people assert that claim properly. Otherwise, the presumption remains that US Inc. and the owners of the bondholders own the strawman. The foundation of our claim is that they did not originate the strawman, but merely altered the original name by changing the upper and lower case name into a same-sounding name spelled in all capital letters without full disclosure. That all-caps name is used to finance the system of power and self-enrichment of US Inc. and its owners at the expense of the enslavement of the people. They do not possess any authority to use the name based on the unlawful object of intent to perpetrate the scheme to reduce the people to slavery and peonage by engaging in fraudulent concealment and a mountain of other crimes. In addition, it is the living being to whom the name refers that provides the labor, substance, and life force that gives value to the strawman, and thereby authorizes the real being to claim superior title to it. Those who expropriate the output of others for their own unjust enrichment, subjugate the populace, and bring about the ruin of those from whom they steal the rights, life force, labor, and wealth, have no legitimate grounds to assert a claim of superior title, either in law, equity, or commerce. There is a sequence of steps that must be done to become free of the bondage system that now enslaves mankind and regain lost freedom and independence. The system has not, to say the least, been forthcoming in educating the people concerning the true legal and commercial situation to which virtually everyone in the world is now subject. A mother having given birth to her baby is not informed that by allowing her child's birth certificate to be registered she is, for instance, 1. Informing on the baby criminally and declaring her newborn infant to be an enemy of the state with no rights, 2. Consigning the child to permanent slavery, peonage, and indentured servitude, 3. Declaring her baby to be fungible goods and the chattel property of the bankers and world powers. If full disclosure, good faith, and genuine meeting of the minds prevailed, as is required for any purported contract to be an actual, bona fide contract enforceable at law, and the people knew the truth, the banks and governments of the world would be out of business.